Good morning. Welcome to the Indian Polity Class. Today we'll have a discussion on salient features of the Indian Constitution. By now, you might have understood the various terms and the terminologies that are being used in the Indian Constitution. So, understanding these points are very important for understanding the whole Constitution at the later times. Now, let me talk to you regarding the salient features of the Indian Constitution. What do you mean by the salient features? When I'm using this word salient features, these are the important characteristics of the Indian Constitution. Otherwise, Indian Constitution was made, was prepared or framed by the Constituent Assembly for working for almost 3 years. 2 years, 11 months and 18 days. And during that time, we have borrowed the various features from some other constitutions. But today, we'll try to understand what are the characteristics that are present in the Indian Constitution, which are making the Indian Constitution is so special. Let us try to understand these points one after the others. I'll open the document. Again, we are coming across with some terminologies and some of the very, very important points here, and we'll try to understand one after the others. Look at this. If you look at the Constitution of India, it has undergone many changes in the last 60 years. So it's more than 60 years that Indian Constitution has come into force. And the amendments or the modifications in the Constitution are to meet the aspirations and the changing needs and demands of the people. So this statement is discussed even in the Constituent Assembly. That is the reason why the constitutional framers also used another concept within the Constitution, that is nothing but amendment of the Constitution. If you prepare or if you frame the rules and regulations which are considered to be very, very rigid, in future it becomes very difficult for the nation to change it. Meaning, the Constitution of India came into force on January 26th, 1950. During that time, the framers of the Constitution, they took enough care to meet all the aspirations of the people of that time. But they are also very clear, in future, the aspirations, the demands, the needs, the requirements will be changing in the society, and accordingly, the Constitution should be in a position to address everything. Hence, deliberately, there is a procedure called amendment of the Constitution that was added within the Constitution. That is one fundamental point. Now look at this. Look at this now. So the amendment of the Constitution are to meet the aspirations and the changing needs and demands of the people. Look at this. So many times we have amended the Constitution in India, and kindly come with me one point after the other. I am highlighting this one. The 42nd amendment of the Indian Constitution that took place in the year 1976 is known as mini constitution because of the large number of changes that it made in the Constitution. What do you mean by this? See, if you remember the year 1976, that was a period of emergency in India. Starting from 1975 up to the year 1977, it was emergency period in India. At the time, Srimati Indira Gandhi was the Prime Minister of India. And during that time, a major amendment has been taken place in the Constitution. And through that, Srimati Indira Gandhi government, they tried to amend majority of the areas in the Constitution. Because it was a major attempt to modify so many areas in the constitution. So there is a criticism with respect to 42nd amendment, and it is called the mini constitution. Kindly remember, in some of the examinations where you are coming across with objective type of questions, they may ask you this question, that is, which amendment is considered to be the mini constitution? Answer is 42nd amendment. So during our course of discussion, we are going to come across with the various amendments, and we'll be touching those amendments, and we'll try to discuss those amendments, why it is important, and why and what exactly happened with that particular amendment. And the two major amendments that took place in India happened in the year 1976 and followed by 1978. These are the 42nd Amendment and 44th Amendment, respectively. We'll try to understand these topics as and when we come across with the 42nd and 44th Amendments. Okay, now look at the document now again. Look at this. So the 42nd Amendment that took place in the year 1976 is known as the mini constitution because of the large number of changes that it made in the constitution. Next one. This is a very, very important one. I have given you in the brackets also, saying that it is very important. In the year 1973, in Keshwananda Bharati case, the Supreme Court ruled that the constituent power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. Now see here, what is the meaning of this? So the Supreme Court has used something called the basic structure. What do you mean by this? What is the basic structure of the Constitution is not mentioned in the Constitution. But every constitution will have its own basic structure. It is nothing but a set of values that are present within the constitution, which are not expected to be modified. Of course, it is nowhere mentioned in the constitution. But since the beginning, so there was a contradiction or conflict between the parliament and the judiciary. Parliament always thinks that it has the ultimate authority to amend the constitution. There is no doubt regarding these particular statements that are used by the parliament. But the highest judiciary in the country, the Supreme Court of India, always it was coming into the picture, and it is trying to protect the basic tenets of the constitution. And that is nothing but the basic structure of the constitution. Accordingly, the Supreme Court in various judgments, it came out talking about the concept of basic structure of the Indian Constitution. This will have a separate discussion under case laws, but before understanding the case laws, we need to understand certain fundamentals. So that is what we are going to try to understand now. Hence, according to the judgments that are given by the Supreme Court, so now there is a basic structure to the Constitution. Of course, the number of items that are listed out by the Supreme Court may extend, may be increased over a period of time. But otherwise, the Constitution under Article number 368 permitted the Parliament to amend the Constitution. But Supreme Court in the year 1973, in one of the very, very important cases, that is the Keshwananda Bharati case, it made it very, very clear, you can amend the Constitution, but without amending the basic structure of the Constitution. And this happened in the year 1973. That is the reason why this particular judgment given by the Supreme Court is very, very important. Okay, so kindly remember this. Now, let's move ahead. Look at this. So, Indian Constitution is a written constitution and the lengthiest constitution and the lengthiest written constitution in the world. What do you mean by this written constitution And if you look at in the brackets, there is one example for unwritten constitution, that is the UK. Let me make it so simple for you with respect to the written and unwritten constitutions. In our previous classes, we have already understood that every country has got its own constitution, and that particular constitution may be either written or it is unwritten. What is the difference between these two? Kindly remember this. So today in the world there is one unwritten constitution, and that is the British Constitution. What is the meaning of this? If the amendment procedure of the Constitution is mentioned within the Constitution, then it is called a written Constitution. Example, India, and we have article number 368. Under this one, the procedure is clearly laid down how to amend the Constitution of India. Hence, Indian Constitution is a written constitution. Almost every country in the world has got a written constitution because the amendment procedure is mentioned within the constitution. But when it comes to unwritten constitution, the amendment procedure is not clearly prescribed within that constitution. Hence, in those countries where we have the unwritten constitution, example, United Kingdom, there is no difference between ordinary bill and constitution amendment bill. Very, very important. On day one, we have understood that in India, we have various types of bills. During that time, I was speaking to you that ordinary bills can be amended. Ordinary bills can be passed with a simple majority, whereas constitution amendment bills must be passed by the special majority. This is what we have discussed. But if you go to this UK, there is no difference between the ordinary bills and the constitution amendment bills, meaning the amendment procedure is not clearly mentioned or prescribed within the constitution. Hence, that constitution is unwritten constitution, whereas India is written. Very, very important. And we know what is the difference between these two now. Next one. And if you look at this, again, India, it is the lengthiest written constitution in the world. This is another important feature. Indian constitution is a written constitution. Indian constitution is the lengthiest written constitution in the world. Now, let's try to see why Indian constitution is so big, why it is so large. Sometimes the people will say Indian constitution is the bulkiest constitution in the world. Look at this. Why it became so bulky? We have listed out some points. Kindly have a look at this. Indian constitution is so large or so big, it is because the Constitution of India has incorporated all the accumulated experiences gathered from the working of all the known constitutions in the world. Yesterday itself, we have seen the sources of the Indian Constitution, and we have borrowed our Constitution from various sources. And every constitution will make its constitution in accordance with the accumulated experiences that were gathered. And accordingly, those constitutions were also changed over a period of time, meaning they were also amended. But when it comes to India, we incorporated, the Indian constitution has incorporated all the accumulated experiences gathered from the working of the all known constitutions in the world. Okay, now next one. And it is so big because the constitutional framers wanted to avoid all defects and loopholes that might be anticipated from the light of other constitutions. What is the meaning of this? So while studying about other constitution, We have come across with so many things. Maybe Indian constitutional framers, they thought that these are the areas which may create some conflict over a period of time, because those conflicts are already occurring in some other constitutions. Hence, deliberately, we wanted to avoid all these problems in the future, and that is the reason why it has been explained in a detailed manner. That is another reason why the Constitution of India is so big. Okay, now look at this. And it is also so big to minimize uncertainty and litigation. So, at any time, there may be a litigation, there may be an uncertainty. And to make it more clear, to make it more lucid, they have elaborated the explanations in the constitution. And next one, we have borrowed so much from the Government of India Act 1935 because the people were familiar with the existing system. This is one reason here why we have borrowed so much from the Government of India Act of 1935. It is because the people are familiar with the existing system. Next one, if it is not a detailed one, the new democracy may be jeopardized. Obviously, it should be a very, very, very valid one. In fact, if it is not detailed one, the newly created democracy, it may be jeopardized, meaning it may be, it may become vulnerable, or it may be very, very risky to run the democracy, because if it is not detailed, obviously there will be so many confusions that will present. Now look at this. Next one, vastness of the country. As the country is very large, there are so many regions, there are so many religions, there are so many cultures, there are so many values, there are so many languages. And in order to accommodate the whole nation into one constitution, the constitution was explained in a detailed manner. How it has been explained, when we come to part 1, 2, 3, 4, we'll try to have a detailed discussion according to this. Now, the peculiarity of the problems that are present in India, maybe regional, maybe language. So these are the problems that are present in the country. So everything has been addressed by the constitution. Look at this. So since beginning, we give this priority. Since beginning lessons, especially from the commencement of the constitution, we give priority, importance, and special focus on certain categories of the people. They are nothing but scheduled castes, scheduled tribes, and other backward classes. For that reason, the constitution has allocated a separate part. Look at this. Part 16 of the Indian constitution has been dedicated to scheduled caste, scheduled tribes, and other backward classes. And what are these dedications and what are the special provisions to them? When we come to part 16, we'll try to have a detailed discussion. Okay, kindly see here. It is not just that is present within the constitution, but otherwise within the constitution itself we have some schedules. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12. So each schedule is also important for us. So during the time of our discussion itself, we'll be coming across with the various schedules, and we'll try to understand each and every point that is related to every schedules. Okay, but here I am talking something about the parts, and the part 16 of the Indian Constitution has been dedicated for SCs, scheduled castes, scheduled tribes, and other backward classes. Next one, if you look at this, in order to accommodate various languages that are present in the country, part 17 has been added, and that part 17 talks exclusively about the official language. What do you mean by this? Let me tell you. If you look at India, so there are so many languages that are present. It seems that there are more than 1600 spoken languages that are present in India. But it is very difficult to accommodate all the languages within the constitution. That's the reason at the time of the commencement of the constitution, 14 languages were picked up, And these 14 languages were added to the Indian Constitution and they were kept in the schedule number 8. Hence, 8th schedule talks about the official languages. But according to the sources, these 14 languages put together, they are spoken by more than 90% of the population in India. But otherwise, there may be some smaller groups who may be speaking a different language. By excluding all those languages, as far as possible, all the major languages have been taken and they were incorporated into the Indian Constitution. And over a period of time, the number of the languages in the 8th schedule has been increased by amending the Constitution. Slowly, we have added the 15th language. Later, we have added 16, 17, 18. Three languages were added. And after that, four more languages have been added. Hence, today, the number of languages in the 8th schedule is 22. In the original constitution, the number was 14. But today, we have 22 languages in the 8th schedule of the Indian Constitution. And these languages have been allocated in the 8th schedule. And in this particular part, the concept of these languages have been explained in a detailed manner by the Constitution. And when we come to that area, again, we'll have a detailed discussion. Because of all these reasons, Indian Constitution has become very, very large one, very, very detailed one. Now, next, look at this. Another one. The emergency provisions are mentioned in the part 18. Part 18 of the Indian Constitution. What do you mean by this emergency provisions here? Sometime back, I was referring to this one. The Constitution of India has provided three types of emergencies. Number one is the national emergency. Number two is the state emergency, otherwise called the president's rule. And number three is the financial emergency. All these three emergencies are mentioned and explained in a detailed manner in part 18 of the Indian Constitution. Separate articles have been allocated and these emergency powers are exercised by the President of India. Again, a very, very detailed one here. Meaning what should be done during the emergency situations. So the government has to gear up, take care of the people, do something which will be needful to the people. Everything is mentioned in the Constitution in a detailed manner. This is another reason why the Indian Constitution has become a very, very large one and a very detailed one. Okay, look at this. We have spoken something about part 16. We also spoken something about part 17 and 18. Look at this. Next one, even the kindly remember. So whatever the parts I am using it here during our discussion, you are expected to remember all the things. Now the next one, even the fundamental rights were made so bulky because of the detailed and elaborate explanation and also the insertion of the concept of untouchability, preventive detention, etc. So many important aspects have been explained in the fundamental rights. I told you already, these fundamental rights are mentioned in the part 3 of the Indian Constitution. Articles 12 to 35, they are exclusively speaking only about the fundamental rights and will have a detailed discussion regarding the fundamental rights. But otherwise, each fundamental right was explained in an elaborate manner. I was telling you some time back, Dr. B.R. Ambedkar, he has given highest significance to part 3 of the Indian Constitution because this part is talking about the fundamental rights of the people of the country. Hence, this is a very, very, very important part of the Indian Constitution. And later, if you look at the part 4A, we have added to the Constitution. By amending the Constitution, so we have added part 4A. Already here, from the date of inception of the Indian Constitution, since 1950, Even during that time itself, our constitution is so bulky. And over a period of time, we have amended the constitution and we have included certain other parts also. For example, Part 4A. For example, Part 9, Part 9A and Part 9B. Example I'm telling you. Like this, we have also added some new parts. Whenever we are adding the new parts, along with the parts, we should also add the articles. Hence, over a period of time, some articles have been deleted and some articles have been added and some parts have been added. When I'm adding something to which is already existing one, the size will become bulky. It will become more lengthy. It will become more detailed one. This is also one of the reasons why the Indian constitution has become a very, very large one. Since the beginning, it is the bulkiest, and over a period of time, it is becoming more lengthy one and more detailed one. This is another reason why our constitution is the largest one. Look at this. Some laws made by the parliament can be amended without undergoing the procedure of the amendment under Article 368 of the Indian Constitution. For example, here, when we come to the discussion on Part 2 of the Indian Constitution, I'll be talking to you regarding the concepts of citizenship. But the Constitution has given a provisions who can be recognized as the citizens of India. At the same time, without explaining all the things within the Constitution has given the power to the Parliament of India, where the Parliament can decide and Parliament can make certain laws, and those laws will be deciding that who should be given the citizenship and who should be denied of the citizenship and whose citizenship can be suspended or terminated. Right? So these are present outside the constitution, hence they are called ordinary laws. But every ordinary law that is made in India is made only in accordance with the provisions of the Indian constitution. Am I clear? Imagine a situation. If these ordinary laws will also become the part of the Indian constitution, then what would be the size of the Indian constitution? It will it will be much more bigger than the existing one. Am I clear? Now, that is the reason why in the beginning classes only I told you the difference between ordinary laws and constitutional laws. Okay, just remember those points. See here, before going further, I would like to give one suggestion to you. As the days are progressing with our discussion here, we started Indian polity. And in the evenings, we are talking something about the current affairs. Over a period of time, we'll discuss about various issues, maybe political issues, economic issues, and social issues. We'll allocate a separate time for that. Apart from this, once Indian polity is over, we'll be reading Indian economy, geography, history, so many other areas are there. As the days are going on, we'll be learning more and more subjects will be accumulated in our brains. During that time, you should be in a position to revise the old topics very fastly. Very fastly in the sense, just by looking at that one, all the points that are related to the topic should come to your mind. That will be possible only when we have the clarity on the subject. The clarity will be developed only through repetitive readings. Hence, in order to avoid any confusion in the future, please go through the classes once again, starting from day number 1. The more you attend the classes, the more you watch the videos again and again, you will enhance your knowledge and that will be giving you the more clarity. For example, once Indian polity is over, we'll be starting Indian economy. During that time, you and me both are focusing more on this Indian economy. During that time, because of any reason, if you neglect this Indian polity, obviously the subject may skip away slowly. Hence, be strong with the subject, each and every subject. Hence, you plan your schedule in such a way, even when I start the next subject, you should be in a position to come back to the previous subjects and revise it periodically. Anyway, I'll tell you how to do it. But the understanding the subject is very, very important, so that our pace of learning will also be increased. Otherwise, it will be slowed down. Hence, I request all of you to go through the topics again and again. Already we have our site kalyansir.net. There I have already given the whole notes. Please read the entire notes immediately after the class every day. Right? Now, let me go to the next point. Look at this. There are some articles that remain in force only so long as the parliament does not legislate on the subject. Example, exemption of union property from the state taxation. Okay, so when we come to this topic, we'll have a discussion. But otherwise, so here, next point. Originally, there were there was a preamble in the constitution. Articles 395 were there, 22 parts and 8 schedules were there. This is the number what we have in the original constitution. But over a period of time, our constitution has been amended. And if you look at the today's strength here, the Indian constitution contains a preamble. More than 450 articles are there, and number of parts has been increased to 25, and the number of schedules is increased to 12. Very, very important. Just remember this. Meaning the lengthiness of the Indian constitution is increasing because of the addition of so many things. Now, another important feature of the Indian constitution. Already we have seen 2 points here. Indian constitution is a written constitution. Indian constitution is the lengthiest constitution. Now, there is another point. There is a single constitution for the entire country except for Jammu and Kashmir. Why it will become a special feature for us? For example, see here, since day one I was talking to you that India is a federation, and we know what is the meaning of the federation. If India is a true federation, the entire country will have one constitution, and each state that is present in the country will have its own constitution. Obviously, if the states have their own constitutions, the state subjects will be mentioned within the state constitution. But India deliberately attempted to go for the single constitution for the whole nation, where the Constituent Assembly also accommodated the state subjects in the Indian constitution. That is the reason why in India we don't have two different constitutions. Only one constitution is there, that is called the Constitution of India, where both the central subjects and also the state subjects have been added. This is the one very, very important point. Because the state subjects are also added in the Indian constitution, the size became very, very large. Is that okay? Right? But we have one exception. That exception is nothing but Jammu and Kashmir. Because it has been added to the Indian constitution, it has been integrated. Sorry, it has been integrated into the Indian Union under a special circumstances. That's the reason why the initial agreement is that let there be a separate constitution for Jammu and Kashmir. And remember, this is the only state in the country where the state is enjoying a separate constitution, that is called Constitution of Jammu and Kashmir. Okay. Now, let me go to the next point. Let me open the document. Indian constitution is both rigid and flexible. Kindly remember this point, both rigid and flexible. What do you mean by this? When I'm using the word rigid here, the constitution can be amended only with a special majority. If the constitution is amended only with a special majority, then it is called a rigid constitution. If the constitution is amended only with the simple majority, then it is called a flexible constitution. If you look at the United States of America, the Constitution of United States is considered to be the most rigid constitution in the world. That's the reason if you look at the history of American Constitution, in the long history, it has been amended only for 27 times so far. But whereas if you look at India, within the short span of less than 65 years, we have amended the constitution for almost 400 times. Indian constitution is also amended with a special majority, and American constitution is also amended with a special majority. But for us in India, special majority is the two-thirds majority. I explained you in the initial classes itself. But whereas in America, the special majority is the three-fourth majority. Hence, it is really a difficult task in America to amend the Constitution of United States. Hence, American Constitution is the most rigid constitution in the world. At the same time, if you look at the Constitution of UK, that is considered to be the most flexible constitution in the world. Already we have seen in UK, there is no difference between ordinary bills and amendment bills. Both are passed in the same manner, both are passed with a simple majority. Hence, the Constitution of UK, because it is amended with a simple majority, it is considered to be the most flexible constitution in the world. But when it comes to India, we are saying that Indian constitution is both rigid and flexible. What is the meaning of this? In the initial days, we have understood during our discussions that Indian constitution can be amended only by introducing an amendment bill, a constitution amendment bill, and that bill will be passed by both the houses of the parliament with a special majority. There is no point in joint session. There is no chance of joint session. Later, it will go to the President of India and it will become an act. This is what we have understood. And what is the procedure? That is the procedure that is mentioned under Article 368 of the Indian Constitution. But kindly remember one important point I am going to tell you now. This will be very useful for our forthcoming discussions. Apart from amending the Constitution, as mentioned under Article number 368, the Constitution also provided a mechanism where some of the areas in the Constitution can also be amended with the simple majority. Hope you are getting it. Indian Constitution is both rigid and flexible, means it is rigid because majority of the areas in the Constitution can be amended only with the special majority. But there are some areas where the Constitution can be amended even with a simple majority. Example, formation of the new states, creation of the new states in India. Recently, we have created a state called Telangana. That Telangana state has been created by amending the Constitution, but we have not used Article 368. Whenever you create a new state, a new state is being taken birth. And if you look at Indian Constitution, The names of all the states and union territories are mentioned in Schedule number 1 of the Indian Constitution. And whenever you create a new state, the name of the new state should be added to the Schedule number 1. When I'm adding a schedule, whenever I'm adding a new name to any schedule, that should be considered as an amendment of the Constitution. And regarding this point, we have no doubt. But how are you adding? How are you amending this one? Are you using a special majority or a simple majority? The answer is it is happening through the simple majority. And whatever I told you just now, that is mentioned under Article number 3 of the Indian Constitution. It is mentioned under Article number 3 of the Indian Constitution. And here we did not touch Article 368. Hence, whatever I spoke to you just now, that will come under the flexible part of the Indian Constitution. Similarly, in some of the states, we also create the legislative councils. Whenever we create any legislative council, Constitution is being amended, but with a simple majority, and we are not touching the special majority. Hope you are getting me all the points. That's the reason why Indian Constitution is both rigid and flexible. This is one very important point. Most of the countries in the world, either they have the rigid constitution or flexible constitution. Just now I gave you the examples. USA is the most rigid constitution in the world, whereas UK is the most flexible constitution in the world. But when it comes to our constitution, this has the features of both rigidity and flexibility, because some areas are amended with a simple majority and other areas are amended only with the special majority. Kindly remember this. Now, let me open the document for you again. Look at this. Indian Constitution is rigid means there is a special procedure for amending the Constitution, just like in the case of United States of America. But kindly remember, there is a difference between American Constitution and Indian Constitution. Both are amended with a special majority, but the special majority is different. In India, it is 2/3. In America, it is 3/4. Next one. Indian Constitution is flexible means with an ordinary procedure, like in the case of United Kingdom, the Constitution can be amended. Example I told you, Article 3, Article 169. This is present outside the purview of Article number 368. Kindly remember, if I am touching Article 368, then we should be using the special majority. Without touching Article 368, if you try to amend any part of the Constitution, then that comes under the flexible part of the Indian Constitution. Okay, now look at this. Next point I'm talking to you. Next point is the India is a federal system. India is a federal system, but it has also the unitary features. I told you already. This is another feature in India. The countries may be either federal in nature or the countries may be either unitary in nature. But when it comes to India, it is a federation with a unitary characteristics. Federal means division of the powers. But I told you already, the division of powers is not permissible every time. There may be some situations which are talking in terms of the emergency. So during the emergency times, the concept of federation will be lost and the nation will become unitary and all the powers are exercised by the central government only. Meaning federation with a strong center. Yesterday also I told you, this concept we have borrowed it from Canadian Constitution. Okay. Next one. We have another feature in India, the Indian Constitution, that is a parliamentary form of government. This form talks about the presence of the nominal executive and the real executive. You know this entire story. I explained you this one in a very, very detailed manner. India is a parliamentary form of government, and the concept of parliamentary form of government was adopted from UK Constitution. Just like in UK, in India, we also have the one de jure head and one de facto head. De jure head is the President of India, de facto head is the Prime Minister. Number two, if you look at this, majority party rule is another symbolism in the parliamentary form of government. And what is the majority party rule? Also, I told you. Next one, collective responsibility to the lower house of the parliament. That is nothing but the Lok Sabha. And I told you collective responsibility means once the elections are over, any party which gets a majority will claim to form the government, and the president will give a chance to the government, chance to the party to form the government. And this particular government will continue in the power as long as they enjoy the majority in the Lok Sabha. I explained you all the points. Just recollect those points. That is one another meaning of the parliamentary form of government. Next one is the leadership of the Prime Minister. Prime Minister for the nation and the Chief Minister at the state level. And the dissolution of the Lok Sabha. What do you mean by this? Because we are dissolving the Lok Sabha, the term of the Lok Sabha will be 5 years. Constitution has mentioned the Lok Sabha term is 5 years, and the state legislative assembly's term is also 5 years. Okay. So that is the reason why every 5 years we dissolve Lok Sabha and will conduct elections. And every 5 years we dissolve assemblies and will conduct elections. And this is another feature of the parliamentary form of government. And India is a perfect example which is completely fixing itself into the parliamentary form of government. Okay. And if you look at the last point I have given in the brackets, so whatever I spoke to you regarding the nominal executive and the real executive, majority party rule, followed by the collective responsibility to the lower house, followed by leadership of the Prime Minister or the Chief Minister, or dissolution of the Lok Sabha or the assemblies. Whatever I spoke to you now, this type of parliamentary form of government is existing both at the central level and also at the state level. Okay, kindly remember this. This is another feature. Now, if you look at fundamental rights, so these fundamental rights are basically meant for promoting the political democracy. These are justiciable. What do you mean by this? For example, see here in India, we always talk in terms of the fundamental rights. They are present in part 3 of the Indian Constitution, right? And these fundamental rights are justiciable. When I use the word justiciable, for the violation of the fundamental rights, I can approach the judiciary, and the judiciary will come to the rescue of the people. Because the judiciary is coming into the picture, because the judiciary is interfering, these fundamental rights are considered to be justiciable. In the sense, the judiciary will come to the rescue. That is the basic point of this. And the people can challenge this before the court of the law. Wherever I am using the word justiciability, that is nothing but we have been permitted to challenge the same thing before the court of law. And remember, the fundamental rights that are present in Indian Constitution are justiciable. Next one. Next point, look at this. Read this once again. Fundamental rights are for the promotion of the political democracy. These are justiciable in nature. They are enforceable by the courts for their violation. And the next one is the directive principles of state policy. I explained you very clearly during the time what is the meaning of the word state. The state is expected to perform the welfare activities. Look at this. They seek to establish welfare state in India, but these are non-justiciable. Just now we have seen what is the meaning of justiciability. Now I am using the word non-justiciable. This is one fundamental difference between fundamental rights and the directive principles of state policy. Fundamental rights are justiciable, DPSP non-justiciable. Very, very, very important. Meaning, the Constitution has permitted the state to perform some welfare activities so that you'll be fulfilling your responsibilities towards the citizens. But because of any reason, if any of the DPSP is not implemented, then as the citizens, we cannot do anything. I am talking exclusively about the directive principles of the state policy. These are non-justiciable, meaning these functions can be performed by the government of that particular time according to its convenience. Because the government has to plan, the government has to allocate the financial resources, material resources, and the human resources. That's the reason why the Constitution cannot put any pressure on the government to perform every activity which is required for the people. Hence, deliberately, the DPSP was made non-justiciable. Remember this, fundamental rights are justiciable, directive principles are non-justiciable. Hence, DPSP cannot be challenged before the court of law. Okay, now I am going to the next point. Look at this. Look at this again. Just remember, always there is a contradiction between the fundamental rights and the directive principles. Okay. Now, when it comes to this directive principles, the government of the day, since the beginning, since the times of this Jawaharlal Nehru, the government always talk in terms of giving highest priority to the directive principles and giving lower priority to the so-called the fundamental rights. But the judiciary always it was trying to say that fundamental rights should be given the priority. So this is a contradiction between the judiciary and the Parliament of India. But in the year 1980, in the Minerva Mills case, the Supreme Court has given a judgment, and I'll just read out that particular point for you. Have a look at this. In the Minerva Mills case of 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and DPSP. So, till the time the Parliament is speaking in favor of the DPSP and the judiciary is speaking in favor of the fundamental rights. So, this contradiction was there since day one. But in the year 1980, it is one of the great judgments that are given by the Supreme Court. It tried to give the balance, put the balance between the fundamental rights and the DPSP. Okay, and this happened through the Minerva Mills case of 1980. Okay, I'll just read it out for you. In the Minerva Mills case of 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights, which are justiciable, and the DPSP, which are non-justiciable. Okay, now the next point is the fundamental duties. This is another important feature of the Indian Constitution, and fundamental duties were not mentioned in the original Constitution. We have seen this, these fundamental duties we have added through the 42nd Amendment in the year 1976. During that time, the Indira Gandhi government has thought that Let us also add some fundamental duties to the citizens. Accordingly, the government has appointed a committee called Swaran Singh Committee, and that committee has recommended for adding 8 fundamental duties. But the government has revised it, and at the end of the day, through 42nd Amendment, 10 fundamental duties were added. And over a period of time, through the 86th Amendment, one more fundamental duty has been added. Hence, today in the Constitution, in Part 4A, a new article is present, that is Article 51A, and that article mentions about all the 10 fundamental duties, but now the number has been increased to 11. Am I clear? So these are the fundamental duties. Hence, this is one of the important features in the Indian Constitution. Look at this. Added through 42nd Amendment in the year 1976, it was based on the recommendations made by Swaran Singh Committee. Part 4A was added for accommodating fundamental duties, and later one more fundamental duty was added through the 86th Amendment of the Constitution. Next one. Next one is a secular state. In India, very frequently you will come across with the word secular. When we use the word secular or secularism here, that is nothing but equal respect to all the religions. If you look at majority of the countries in the world, most of the countries and their constitutions are talking in terms of the official religion of the state, meaning the state will strive to promote that particular religion. Highest regard and respect will be given to one particular religion, and remaining all other religions are not given the priority. So this is the case with various other constitutions and various other countries in the world. But when it comes to India, deliberately we have adopted the concept of secular state, where equal respect will be given to all the religions, and that is the reason why in India we don't have any official religion. There is no official religion for the state. India is a land where various religions are present in the country, and India has accommodated all the regions with equal love and affection. That's the reason why India is lauded throughout the world because of its principle of secularism. It's a very, very, very great thing. Very few countries in the world, they have this concept. Okay, and this is the meaning of the secular state. Kindly remember, whenever, wherever I am using the word state, you should recollect all the points what I told you in the previous class regarding the word state. The Constitution does not uphold any particular religion as the official religion, but otherwise equal respect will be given to all the religions. Okay, next point. Next point, if you look at this, universal adult franchise. What is the meaning of this? Universal adult franchise is nothing but all the people in the country are permitted to vote. The only limitation is that anybody who is a citizen of India and not less than 21 years of age is permitted to vote in the election. Election means it is a general election. And I am talking to you about the original constitution. Original constitution mentioned the voting age as not less than 21 years. But over a period of time, in the year 1989, through the 61st Amendment, we have modified this particular clause and we have reduced the age from 21 to 18. That's the reason in the previous elections, all the citizens in India who are not less than 18 years of age were permitted to vote in the general elections. But what is so important regarding this? Most of the countries in the world, they also have the concept of universal adult franchise. They are also permitting the adult citizens of their country to vote in the elections. But most of the countries in the world, they started practicing universal adult franchise after the commencement of the constitution. They have adopted this principle later. But when it comes to India, from day one, from January 26th, 1950, rather from November 26th, 1949, we started adopting the concept of universal adult franchise. With the commencement of the constitution itself, the concept of universal adult franchise has been introduced. Hence, it is one of the important features of the Indian constitution. Kindly remember, I spoke to you regarding the voting age in India. Originally, it was 21. Later, through 61st Amendment, it has been reduced to 18. Hence, in India, in every general election today, all the citizens who are not less than 18 years of age are permitted to vote in the elections. Kindly remember this. Next one. I am going to the next point. Look at this. Emergency provisions, I told you already here. These emergency provisions are provided in the Part 18 of the Indian Constitution. And there are three types of emergencies, I told you: national emergency, state emergency, and the financial emergency. Look at the last point. During the national emergency, India, from the state of federation, it becomes unitary. I told you already, right? Three-tier government. What do you mean by this? Originally, there is only central government and state governments. But over a period of time, a third level government was added at the lowest level. Through the 73rd and 74th amendments, three-tier structures was created, and Panchayati Raj and municipalities were made the constitutional bodies. Okay, kindly remember, these are all the salient features of the Indian Constitution. Look at this. The Constitution of India has undergone many changes through the various amendments. Look at this. The 73rd Amendment Act added 16 articles that provide for establishment of and elections to the panchayats. Look at this. They are comprised in a new part called Part 9. Through the 73rd Amendment, 11th schedule was also added. Are we not increasing our size? The size of the Indian Constitution? It is becoming more lengthier day by day, year by year. Similarly, look at this. The 74th Amendment Act added 18 articles and inserted Part 9A to the Indian Constitution, and it provided for the establishment and the elections to the municipalities. Next one, the 74th Amendment also added the 12th schedule to the Constitution. I have a question here. Kindly have a look at this. Read the question and answer it. Which of the following determines that the Indian Constitution is federal? A, B, C, D are given. Of course, I gave you the answer here for you. But read out all the statements, 1, 2, 3, 4. It's a written and rigid constitution, an independent judiciary, vesting of the residuary powers with the central government. Okay, A, B, C are wrong here. And if you look at the D, Indian Constitution is federal because of the distribution of the powers between the center and the states. Okay, but every time I tell you here, kindly remember, the word federation is nowhere mentioned in the Constitution. Okay, just remember this particular point. If you go to this, some points are there, something miscellaneous. Kindly have a look at this. Some miscellaneous points. The Constitution of United States of America deals only with the federal governments, but whereas in India it deals with both federal governments and also the unitary sometimes. The states in United States of America will frame their own constitutions. They will make their own amendments. In India, Jammu and Kashmir is the only state which is permitted to have its own constitution. I told you already, when we speak about article number 370 that provided special status to Jammu and Kashmir, let us have a detailed discussion. Next one. Some of the provisions are amended in the constitution with a simple majority. Yes, what are they? Changing the names of the states, changing the boundaries of the existing states, abolition or creation of the legislative councils, which is mentioned under article number 169. Next one is the administration of the scheduled areas, administration of the scheduled tribe areas. Next one is the creation of the legislatures and council of ministers for union territories under article 239A clause 2. Okay, right? See here, kindly remember. So this is the topic with the salient features of the Indian Constitution. Tomorrow when we meet morning 5 o'clock, we'll have a discussion on making of the Indian Constitution, and after that we'll look into the preamble. Once the preamble is over, then we'll start reading part 1, part 2, part 3. Like this we'll be going ahead. And one more suggestion from my side, already I told you, please go for repetitive readings. The more number of times you repeat, the more number of times you read, it will become easier for you to understand the future classes. Once you understand the Indian Constitution thoroughly, take it for granted, your 50% of the preparation for the whole examination is over. Take it for granted. So this is what my experience says. Hence, in order to achieve IAS in the first attempt, you need to work. You need to work continuously, and with lots of consistency, you should go ahead. Okay, and we'll meet in the evening at 9 o'clock for current affairs. Otherwise, for Indian polity, we'll be meeting tomorrow morning at the same time, 5 o'clock. Okay, thank you so much for being with me this morning. I wish you all the very, very best and have a very, very, very good day. Thank you so much.